Our meeting of Education Innovation Policy will unofficially come to order. We do not have a quorum yet, but our committee legislative assistant will be watching for members, so I'll know when to call this to order officially. Members, today we have on our schedule all bills that deal with improving our code of ethics, our background checks, our mandatory reporting, and other issues that have come forward. So this is going to be a rather, I think, interesting but intense meeting in that there are so many different sections to many of these bills, and we'll want to pay close attention. We also have amendments that we need to address. You can tell I'm trying to just make time so I can call the meeting to order officially. Let's see, what else can I say? We've spent a long time preparing these bills. Do we have quorum? We need one more, okay. So let me call to the testifying table Representative Jen Loon. And we'll just take a minute here to get organized. Representative Loon, I can't move your bill yet, but unofficially, will you discuss the background behind, we have quorum? This meeting comes officially to order, and with that, the chair will move House File 2795 to be re-referred to the Committee on Transportation. The chair also moves the H 2795A2 amendment. Welcome, Representative Loon, to our committee. It's so great to have our finance chair in front of us to explain a very important bill. I have moved the amendment, and I think because it's rather substantive, I'd like you to walk through it. So members, will you pull out your A2 amendment to 2795 as we listen to Representative Loon explain it after you introduce yourself, Representative Loon.
Thank you very much, Madam Chair, and thank you, members, the Education Innovation Policy Committee. I'm very pleased to present House File 2795 to you. I'm just roughly titling it the Teacher Code of Conduct Bill. And I wanted to preface my remarks first by saying that, you know, there's over 50,000 teachers in the state of Minnesota, and by far and away, most of them are excellent representatives and role models for our students. They do a tremendous job. They are incredible people of the highest character. Unfortunately, we do have a few rare instances that cause concern and things that happen, conduct that transpires in which I believe the teacher should be disqualified from having a license. We've heard a few of those instances talked about in the news, and they are always of concern to parents and obviously to legislators, as we are responsible for making sure that we are only putting people that we would want in front of our own children in the classroom. So with that, unfortunately, we do have to write legislation for those few rare examples, but that is the type of bill that we are considering today. So I'll first talk a little bit of just about the amendment, and then I'll talk about the bill in whole. The A2 amendment is a few additional measures, and most of these, not all, but most of these were suggestions made by the Professional Educators Licensing and Standards Board to the body of House File 2595. And so the things that would be added to the bill would be the ability to repeal the current law which allows educators or other school employees to begin working while they are waiting for a criminal background study. And so PELSB has suggested that we would no longer allow people into the classrooms if their background studies have not been completed. Again, I think that's a very sensible suggestion on their part, and so we've incorporated that with this amendment. Secondly, there's a cross-reference for disqualifying criminal convictions in section 214.10, which governs the examining and licensing boards. And so basically what we're doing is taking all of that statute and sweeping it in to this legislation. If we didn't do that, we would leave maybe one or two provisions behind, which are very similar to other disqualifying criminal convictions. And so we're just, I'm opting to add all of them in. Thirdly, we would authorize PELSB and BOSA, Board of School Administrators, to suspend an educator license during a pending investigation into a report of conduct that would be grounds for license revocation. And finally, would we require law enforcement to report allegations to either PELSB or BOSA? So if law enforcement had been informed and begun an investigation, perhaps at the request of a school administrator or a school board, that information would be reported to our licensing entities. So that is the A2 amendment, Madam Chair.
Thank you, Representative Loon. Would you say your name for the record, please, to ensure that we have this official?
Thank you, Madam Chair. Yes, Representative Jennifer Loon.
And members, are there any questions in regard to the amendment? Representative Mary Kunesh-Podein.
Thank you, Madam Chair. Thank you. And maybe this isn't the right time, or maybe you're going to cover this, but would this also cover those unlicensed community experts that we would be allowing to come into the schools? Are they also under this umbrella of scrutiny?
Representative Loon.
Thank you, Madam Chair. Yes, but I would allow, if you would have a nonpartisan staff, just to clarify.
Ms. Para, would you clarify, please?
Thank you, Madam Chair, members. The community experts, anybody who receives a license from PELSB is covered by this. So all the
Tier 1.
educators that were previously community experts or had various waivers and will now have licenses of any tier under the licensure changes that were made last year, these provisions would all apply to them.
Wonderful. Thank you.
Thank you, Representative Kunesh-Podein. Representative Erdahl. Question to the amendment.
Yes, thank you, Madam Chair, and Representative Loon on line 313. It refers to physical abuse, sexual abuse, neglect by a person licensed, that portion. I'm just wondering what the definition of physical abuse is. I mean, as a teacher for 35 years, I mean, there certainly were instances where, you know, a teacher felt it necessary to restrain a child or remove a child from a classroom or whatever. And I know that a lot of opinions have changed over the years. I'm just wondering what you view today as what would be covered by your bill regarding physical abuse.
Representative Loon.
Thank you, Madam Chair, and Representative Erdahl. Well, I think, you know, obviously there could be differences of opinion on what abuse is, and so it would be netted out through an investigative process, you know, initiated or either initiated by the school or having law enforcement review that.
Representative Erdahl, follow up.
Thank you, Madam Chair and Representative Loon. And I guess I kind of thought that would be the answer, and it still leaves me a little bit perplexed. Wondering if there is, if council staff knows if there's a legal definition of what is physical abuse.
Ms. Para.
Madam Chair, members. So the term here, physical abuse, sexual abuse, or neglect, that's generally how the statute on maltreatment, that generally means maltreatment. And so the statute on maltreatment, which is section 626-556, does have a definition of physical abuse. which means any physical injury, mental injury, or threatened injury inflicted by a person responsible for the child's care on a child other than by accidental means, or any physical or mental injury that cannot reasonably be explained by the child's history of injuries or any aversive or deprivation procedures, or regulated interventions that have not been authorized under Section 125 AO 942 or 245 825, and it goes on to give some, the definition goes on from there. But that is the definition that is used under the maltreatment statute.
Representative Erdahl.
Madam Chair, and thank you, Ms. Parr, for that. I think that's very helpful. Would you assume then you could take a child by the arm and reasonably escort him from a classroom?
Ms. Para, maybe we'll call on Mr. Arnston's at the table, and he is the government liaison for principals and other school activities. So, Mr. Arnston, please introduce yourself.
Madam Chair and members, I'm Roger Arnston. I represent the Elementary and Secondary Principals Association. I just whispered into Representative Loon's ear here that I actually do have quite a bit of experience with this. And one of the key things that answers Representative Erdahl's question is, and as council was going in that definition, buried in there also are reasonable force exceptions. So the use of reasonable force by a teacher or principal to restrain or correct a child, as Representative Erdahl was asking, is a statutory exception to the physical abuse piece. So it really isn't a changing of standards or practices or that sort of stuff here. That is well defined in the statute, and there's significant practice on that. So I think you've got what you want, that the author has what she wants here, Madam Chair.
Thank you for that clarification, and thank you, Ms. Para. Unless
then-
you had further to, no. Any
no,
further
thank
questions?
you.
Representative Erdahl, you're okay. Very good. Any other discussion? Seeing none, all those in favor say aye. Aye. Those opposed, nay. The motion prevails, and the amendment is adopted. And Representative Loon, House File 2795 as amended is in the order in which you'd like to present it. Please proceed.
Thank you, Madam Chair and committee members. So again, thank you for adopting the amendment. And to just briefly describe what is in House File 2795 as amended. First, I propose to take the Teacher Code of Ethics, which is already in rule, and put that into statute. And so the entirety of that is placed in statute with the addition of the prohibition against sexual contact with a student. And that is an addition to the Code of Ethics, which I would propose to codify. Secondly, it would require periodic criminal background checks. And right now, when someone applies for licensure, there is an initial background check, but there are no subsequent checks done. And so I am proposing that periodic checks be done perhaps every 3 to 5 years. Thirdly, I would include stays of adjudication in criminal background checks for school employment, and that would include bus drivers. And obviously, there's some very specific reasons for doing that. We've had incidences of people being hired as school bus drivers. There were stays of adjudication for sexual contact with children in their past. Those types of legal processes do not show up in a criminal background check. And I think it's important that that information be provided so it can be known when the licensure or hiring process is considered by school districts. And then I would expand the list of crimes that automatically deny or require a revocation of a teaching license. It would include things like domestic violence or domestic assault or embezzlement of public funds. And many of those things are similar to legislation contained in Representative Fenton's bill. So I won't go into great detail on that unless you have specific questions. Next, denying a teaching license for a felony conviction or a gross misdemeanor involving a minor, and with an option for an applicant to request consideration for good cause. If they feel there's a reason their case should be reconsidered, they may do that. I would propose denying or revoking a teaching license if the teacher engages in sexual conduct as defined under 601-321 subdivision 11 with a student enrolled in the school where the teacher works or volunteers. And I would just point out that this says engages. It does not have to be a conviction. for this to be invoked. I would update statutes requiring immediate discharge of a teacher for convictions of crimes that automatically deny or revoke a license by the Educator Board. Requires the Educator Licensing Board to report any alleged mistreatment of a student, regardless of when the student or the incident occurred, to law enforcement and to the appropriate local or agency responsible for investigating reports of maltreatment. The Department of Education is designated in statute to investigate allegations involving school facilities, but again, this would make clear that Pelsby and BOSA are required to immediately report any alleged incidents, regardless of whether they occurred recently or within the past number of years for investigation. And finally, I would update the mandatory reporter of child maltreatment law in section 625.556 to clarify that members of the board of licensing entities are mandatory reporters and require any agency responsible for investigating reports of maltreatment of a minor to share those reports with the licensing entities. And so that is a rundown of the major provisions of House File 2795, Madam Chair, with the amendment. Again, I want to emphasize that we have amazing, wonderful people as teachers in our classrooms. But we have had some instances, some rare exceptions to the rule where people who in my opinion, should not be teaching have been allowed through, either through loopholes in the law or processes that are not I think, airtight in terms of making sure that allegations are investigated and making sure that past conduct is something that is reviewed before we allow people to teach or work in our schools or drive our children to school on the school bus. So we want to make sure we are doing everything we can to reassure parents that they can know that their children are safe, they're in good hands when they send them off to school. And I think this bill helps accomplish that.
Thank you, Representative Loon. Members, before we start questioning the author, I'd like to bring up Representative Fenton to talk about House File 2777. I'm not going to move it at this time, but she has some specifics in there under grounds for revocation that I would like her to address. So welcome, Representative Fenton. Please say your name for the record and tell us how your bill is a complement to 2795 as amended.
Thank you, Madam Chair, members. I'm Representative Kelly Fenton. And essentially, House File 2777 identifies that our new professional educator licensing and standards boards has a very difficult task to do. And the former Board of Teaching had much discretion as to who received a license to teach. And unfortunately, there was some lack of clarity and some slipped through the cracks. And I do want to also, I agree absolutely with Representative Loon that in the state of Minnesota, we have some of the best teachers, I think, in America. I'm actually a former teacher as well myself. So what this bill does is it adds offenses to the list of grounds on which the Pelsby may refuse to issue, renew, or automatically revoke a teacher's license to teach. Some of those are a qualified domestic violence related offense as defined in section 609.02, subdivision 16. Domestic assault under section 609.2242. Essentially, it was already against the law engaging in hiring or agreeing to hire a minor to engage in prostitution under section 609.324 subdivision 1, but we added 1A or 2 to that. Criminal sexual conduct under, that's 2.12 under several statutes there. And embezzlement of public funds under section 609.54. There's also some cleanup language from shall to must. As well, the bill adds a cross-reference to this list of statutes requiring a school board to discharge a teacher effective immediately upon notice of licensing action based on certain criminal convictions. And then finally, Pelsby must also refuse to renew, revoke a teacher's license is convicted of a felony or gross misdemeanor involving a minor, and there is also a process in here for an appeal.
Thank you, Representative Fenton. Members' questions for Representative Loon or Representative Fenton or both? Representative Kunesh-Podein.
Thank you, Chair. Representative Fenton, what constitutes the embezzlement of, did you say public funds? What does that look like?
Representative Fenton.
Thank you, Madam Chair and Representative Kunesh-Podein. I'm going to ask if they could, our nonpartisan staff can read the section under the statute, but I do want to give some background to this. There was a license given to an individual teacher here in Minnesota that had embezzled over hundreds of thousands of dollars from a school lunch program of the most of our needy and hungry children in the state of Wisconsin. Wisconsin fired the teacher, and the teacher came here and a license was issued. So under that, that's how this came to be in there. And I'll have our nonpartisan staff read this section 609.54.
Ms. Para.
Madam Chair, members, Section 60954, embezzlement of public funds. It's fairly short, so I'll read the whole thing. It's whoever does an act which constitutes embezzlement under the provisions of Minnesota Constitution, Article 11, Section 13, may be sentenced as follows. And then it's just a couple clauses saying, the value is $2,500 or less. It's imprisonment for not more than 5 years, or payment of a fine not more than $10,000 or both. Or if the value is more than $2,500, to imprisonment for not more than 10 years, or payment of a fine of not more than $20,000 or both.
Representative Kunesh-Podein, follow up.
Sure. So would that is that outside of the school, or is that just within the educational arena? That they would be disqualified from receiving a license?
Ms. Para, would you like our other researcher to come forward? Mr. DeBolt, would you come forward, please, and take a place at the table? We have two experts with us this morning. Please say your name for the record and
Good morning,
begin.
Madam Chair. Jeff Diebel from House Research, excuse me. The
Face to face, that's good.
the reference is to a embezzlement under the Constitution, so no, it wouldn't be limited to the school setting.
Great, thank you.
Thank you. You might want to stay there for a while. Other questions? Representative Bennett.
Thank you, Madam Chair. I'm just wondering, would any of these expansions or additions, such as the disqualifying offenses or the schedule for how often they'll do background checks, apply to substitute teachers at all?
Representative Fenton, Representative Loon, either one of you. Representative Fenton.
Thank you, Madam Chair, Representative Bennett. I would like to think so. I myself was a substitute teacher here in Minnesota. I was subject to background checks, so absolutely I would think, but I can have someone with nonpartisan research verify.
Ms. Para? Really in demand today, but this is good. Substitute teachers.
Madam Chair, members, substitute teachers would be subject to, I believe they're getting licenses now under this system, so they would be subject to any sort of new license or renewal license application, which would require a background check, and then also the school district, any employees it hires have to go through the background check. So there's two systems there.
So, Ms. Para, if they are hired to be a substitute, regardless of their status and licensure, they are subject to this?
Madam Chair, yes.
Thank you. Other questions from members? Representative Pryor.
Thank you, Madam Chair. This would be for Representative Loon. As you described, the background checks they would still be continued periodically every 3 years, and it's paid by the teacher.
Representative Loon.
Madam Chair, Representative Pryor, I think the issue of who pays could be one that comes up perhaps in testimony today, and I think this may be an issue that we need to continue to work on. I would imagine that teachers who are hired, who are currently employed in schools, may want their employer to pay those sort of periodic background checks, and so the issue of how much that would cost districts has been raised. We are looking at a couple of options. There is a system, and I'll probably not get this correct, I want to say it's called the CLEAR system, that will pull up a list of sort of new crimes or new evidence that would pop up sort of in whole, but I think it only covers the state of Minnesota. It may not be a nationwide background check, so if you had a conviction or an arrest in another state, it may not show up. So but that is an issue that I think may continue to be refined as this bill moves through the process.
Mm-hmm. Thank you.
Thank you, Representative Pryor. Follow-up?
Just a quick follow-up. It says that before someone can begin teaching, there has to be a background check.
Yes.
Do we, any familiarity with how long it takes to get a background check? And I guess it would be a national background check.
Representative Loon.
Thank you, Madam Chair. Actually, no, I'm not quite certain how long it takes. I don't think it's terribly long. Maybe one of the other testifiers. I know when my youngest daughter was in preschool, I was a substitute teacher in preschool, and I went through a background check, and I think I got results within less than 2 weeks, but I would maybe have one of the testifiers coming talk about that process.
And I'm a Sunday school teacher, Representative Pryor, and so I had to have a background check a few years ago. I just went to the BCA and got it almost instantly. So, I mean, that works, but we don't expect our teachers to do that. They have a system in place in every district, but we'll find out how long it takes and to whom they may refer their.
Madam Chair, that's because you have such a short record.
Yeah, that's right. Actually, they gave me the wrong, the first time I did it in teaching Sunday school many years ago, when they first required it, they actually looked up the wrong Erickson because they looked up a Sandra instead of a Sandra. And they handed it to me, and I said, I'm not this person. And boy, were they embarrassed. I said, did you not check my Social Security number? That was just really something. Let's continue on track, though. Other questions for the authors? Representative Ward.
Thank you, Madam Chair. As you're looking at some of the details of this, I think it would be helpful to know what the charge is. I think I know, but I think we need to know what we're asking our school districts and our teachers to pay, knowing how much our teachers spend in the classrooms already, and there's some issues about how much we're paying them. And at the same time, if the employer is paying for it, then it becomes an unfunded mandate unless we provide some money for it. So I'm just concerned about the flow of money and who's actually going to end up paying for this. And if every 3 years, you know, it doesn't seem like a lot of money to some people, but to some it's going to be. And I just would like a little more clarification on that at some point.
Thank you, Representative Ward, and we'll follow up on that. Are there other questions? With that, let's take testimony. We have testifiers here from MCASA and the AMSD and school administrators. Testifiers, you have 5 minutes at the table, so if you could get to the point, we'd appreciate it. And members, be ready to ask questions of the testifiers if you wish. Welcome, and please say your name for the record and begin.
Thank you, Madam Chair. My name is Caroline Palmer. I'm the Public and Legal Affairs Manager at the Minnesota Coalition Against Sexual Assault. Before I go on, I just wanted to clarify, should I just testify to Representative Loon's bill right now and save comments on Representative Fenton's bill for later, or do them both at the same time?
You can do both at the same time. I will move her bill officially after we have finished 2795 as amended, but I think because the bills are a blend, I think that would be just acceptable. Thank you.
Okay, thank you. So I just wanted to be here today in the committee, first of all, to thank you for putting so many bills together in a committee hearing that address safety for youth in school. The Minnesota Coalition Against Sexual Assault, or MNCASA, is very supportive of all of these efforts, and I just wanted to make a couple of quick points about each pieces of legislation. And I also would like to extend my thanks to Representative Loon and Representative Fenton for moving these bills forward. First of all, with regard to the current bill, House File 2795, I'd just like to point out a couple of key areas. First of all, I want to echo how much admiration we at MNCASA have for teachers as well. We work with them quite a bit on prevention measures for sexual assault, and we know that we are talking about sort of the rare circumstances today. We appreciate that this bill sets up a process for cross-reporting neglect, physical and sexual abuse with the appropriate child welfare, law enforcement, and other agencies, and we're particularly happy to see clarifications around mandated reporting obligations. We're also very pleased to see review of background checks, as well as specific requirements for school bus drivers. This has actually been an issue that MNCASA has been thinking about for many years, and so it's great to see it here in this bill. And we're really happy to see that there's a goal of ensuring that individuals who are involved on school buses are not in a place to take advantage of children. With regard to Representative Fenton's bill, I just wanted to talk about how pleased we are to see the grounds for revocation or suspension of license that are expanded to include stays of adjudication related to criminal sexual conduct, domestic abuse, and solicitation of a minor involved in prostitution. And we also are really pleased to see the refusal to issue a new licensure when there is a conviction that involves a minor. Again, we've heard many stories in the media lately. We hear many through our member programs about instances in which sometimes teachers or other professionals kind of fall through the cracks. And it's just so important that we have ways that we can watch for that and make sure that youth are safe as possible in school. So I wish to thank the committee and thank both of the bill authors and really all of the bill authors today who have come forward to talk about this issue. I'm happy to answer any questions.
Are there any questions for Ms. Palmer? Thank you very much for your testimony. Mr. Grunquist and Mr. Amoroso. Mr. Amoroso, you're on deck. Welcome to our committee. Please say your name for the record and begin.
Thank you, Madam Chair. Scott Grunquist with the Association of Metropolitan School Districts, and I will be brief. Just wanted to thank Representative Loon, Representative Fenton, and the other offers for bringing these bills forward, and we, MST, does support these bills moving forward today. I just would like to say for the record, we want to continue to work with Representative Loon on the one issue that did come up earlier, and that is the frequency of the background checks and who pays for them or how they get paid for. We think that's imminently solvable issue and look forward to working with Representative Loon on that. So I'll leave it at that. Thank you, Madam Chair and
Are there any
members.
questions for AMSD, Mr. Grunquist? Thank you. Mr. Amoroso. You know the routine. Please say your name for the record and begin.
Thank you, Madam Chair. Gary Amoroso, Executive Director, Minnesota Association of School Administrators. Once again, I can just say ditto to Mr. Grunquist and the prior testifier. But I do also want to stress, as Chair Loon stressed at the beginning of her testimony, that we are dealing with a very, 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 very small percent of teachers and administrators that are licensed in the state. And I want to make sure that our public is also aware of that and understands that. We also support the direction that Chair Loon is going with her bill. And the one conversation we'd like to continue is what Mr. Grunquist mentioned, the background checks every 3 years. That could create a challenge for districts, not only potentially financially. We heard from our colleagues in Anoka yesterday that could be up to $75,000+ a year. And when you look at Anoka Hennepin, that might not seem like a lot of money, but that could be the cost of one teacher. And so we're interested in having further conversation about who would pay for the background check, and is it necessary to do 3 years, or is there another period of time that would work for everyone? But we appreciate Chair Loon bringing the bills forward, and we do support moving in this direction and would stand for questions.
Thank you, Mr. Amoroso. Any questions? Then we have at least one testifier with concerns. Meg Luger, would you come forward, please? Say pages before you leave. Whoa, 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 whoa. Pages, come back. Ms. Luger, please sit down. I saw the pages out there and I was going to interrupt earlier. These are our pages this week, and can you just shout out the school from which you've come? Just where you're standing, start here in the aisle.
Holy Family, Medina High School.
Oh, say your names too, please. That's most important.
I'm Carly Hilgers. I'm from Holy Family Catholic High School.
I'm Zoe Iyer. I go to Medina High School.
I'm Shohana Emery and I'm homeschooled.
I'm Sonia Hansen. I go to Henry Sibley High School.
I'm William Welsh. I go to St. Paul Academy.
Cayenne Corder, Red Wing High School.
Well, thank you very much for sitting in on this testimony and the presentation of these bills, and we appreciate your work on the House floor and what you'll be doing in committees, so thank you very much for visiting us. I'm sorry, Ms. Luger. Please introduce yourself and begin.
Sure. My name is Meg Luger-Nicolai. I'm an attorney with Education Minnesota, and I'm here to talk about a couple of concerns. And thank you, Madam Chair, by the way, forgot to start out right. And thanks, Representative Loon, we've already had a little bit of conversation about this. Probably 4 areas of concern, and I can clear away the background check thing off the top, is that we would also obviously share concerns with some of our partners in education about the relative number and then the cost. It'd be a concern if teachers have to bear that expense on an ongoing basis. The concerns that I have today, though, are also are substantive with respect to, first of all, the inclusion of new offenses that are automatic revocation offenses. Under the status quo in the current milieu, it is possible for the Board of Teaching to revoke the license of a teacher who's committed a crime of any level, felony through misdemeanor, depending on the nature of the crime and depending on the board's level of concern regarding the safety of students and the teacher's competence. Under the statute, there is less, now we're treating things with kind of a shovel instead of a scalpel in terms of the precision with which we look at problems. And so any type of, for example, theft of public funds, whether or not it's a misdemeanor or a felony, now becomes an automatic revocation expenses. As an attorney for the State Teachers Union, I work with teachers who have licensing issues, and often, and one of the more common cases we see are individuals who have mishandled activity funds. And most of the time it's not because of a grand criminal conspiracy, because we're talking about a couple $100 at a time. It's because of stupidity and lack of training, and I'll be totally blunt on that. So when those cases occur, the charge can be theft of public funds. That if you, for example, mishandled a few $100s worth of activities funds, you'd be barred from ever teaching again if there was a conviction or a stay of adjudication in this case. It is also the case that, and I think Representative Erdahl addressed this a little bit, the question of what constitutes child abuse isn't always something that warrants permanent removal from the teaching profession. And again, when you make something an automatic revocation offense, there's really no room for the board to determine how serious the issue was, and then additionally, whether or not the individual can redeem him or herself. Because certainly one of the concepts in our criminal law, and I think one of the things that we try to apply in licensing statutes, is a question of whether or not somebody can be redeemed. And I also think that although the board's intent is to ensure that teachers are role models in the community and the school community, an individual who has fallen, gotten up, and gotten better can be a role model for getting better. So those are things that I think are worth thinking about. The other issue is that this covers both stays of adjudication as well as criminal convictions. A stay of adjudication isn't the same as a criminal conviction. It is by definition a stopping of the criminal process. And it's a tool that prosecutors, judges, and defense attorneys use to resolve matters and to ensure that there's a smooth criminal docket, among other things. But it is not, you are not afforded the same level of process that you are in a conviction. So the inclusion of that as sort of an equivalent is a concern. The union has no problem with the inclusion of offenses related to sexual conduct, and we have also talked with Representative Loon about the relative levels of scrutiny for certain types of contact. We're not crazy and we're not unrealistic, but some of the offenses that are included are things for which reasonable minds can differ as to whether or not that should be a permanent bar to teaching. And we'd like to see the board retain the discretion and to use their tools as educators and members of the public and parents to look with the same eyes that I know Representative Loon wants to at these situations. So we hope that we can continue to have conversations and be partners in crafting this legislation.
Thank you, Ms. Lugar. Representative Ward has a question.
Thank you, Madam Chair. And I would appreciate a little bit more expansion on educators having made poor choices or not being trained well in how to handle small amounts of activities monies or something like that. Where are we seeing a problem and what can we do about it?
Ms. Lugar.
Thanks, Madam Chair. One of the most common problems that I see are individuals who keep, for example, a kitty. They are receiving activities funds or fundraising receipts if they're cooperating with a booster club, and they keep out a little cash fund so they can make incidental purchases without having to use a P card or go through a requisition process. It's not a great strategy. It's not what I would recommend, but I'm always thinking about the worst case scenario, and most other humans aren't. And so those individuals think that's perfectly fine, especially if they haven't had training from an activities director on a standard money handling policy, which most districts have, but not all train on. So that's an issue where, for example, and Representative Loon has already heard my sob story about an individual who was a yearbook advisor who mishandled about $243 in funds, and she used it to purchase a camera that the district didn't want to purchase. They had, that was considered theft of public funds because she had done it outside the normal purchasing policy, and she was convicted of a gross misdemeanor. She'd be ineligible to teach ever again. That's nuts. She's teaching now, she's teaching successfully, but she isn't the yearbook advisor anymore. That's an appropriate punishment, and this takes away our ability to kind of meet things out in a proportional way.
Representative Ward, follow up.
I would really like, thank you, Madam Chair, I'd like to understand better what school districts should be doing, what policy processes are in place to be sure that people are trained so they don't end up making foolish choices unintentionally, probably in most cases, collecting money for some project outside of, for an extracurricular activity, and then being charged to purchase things with it, items with it. How do we manage to be sure that teachers are getting the support and the training that they need?
Thank you, Representative Ward. Representative Christensen.
Thank you, Madam Chair. And Ms. Lugar, could you detail a little bit, you talked about things that might not be grounds for automatic revocation. Could you talk about what you consider to be, what you don't think should be automatic grounds?
Ms. Lugar.
Representative Erickson, and keep in mind that I'm extemporizing here, and I'll probably hear about it from my boss later. I think automatic revocation shouldn't, first of all, I think we need to look at levels of offenses. So things that are classified as misdemeanors, anything, or gross misdemeanors, may be a revocation offense. It may not need to be an automatic revocation offense. I think things that are property crimes, we need to look at both the levels of offense and then whether or not that actually compromises student safety. In many cases, it doesn't. I think things that are clearly on the list of automatic revocation offenses are things that make children less safe, with the caveat that there are certain things that are classified as child abuse under the law, and this is also true in the status quo, that may not represent an ongoing danger to children. It may represent a bad moment in somebody's life, but may not warrant automatic revocation. It may warrant remediation, which the board often requires. For example, they require that individuals undergo training before they return to the classroom. Those are opportunities that will be lost if we don't have that flexibility.
Representative Christensen.
Thank you again, Madam Chair. And Ms. Lugar, could you go into a little more detail about a situation like that under that things that are classified as child abuse that you were referencing?
Yeah, and
Ms. Lugar.
Madam Chair, it's my fortune to deal with a lot of these cases, and so I always have a great number of anecdotes at my disposal. I worked with a teacher who was teaching a class, and a student fell asleep in the class, and in order to wake the student up, and I assume provide an object lesson to the rest of the class, he dropped a book bag on the kid's head. And the book bag, I think, had an organic chem textbook or something in it and made it considerably heavier. So that became a gross misdemeanor child abuse case. Now, is that teacher somebody who historically or habitually hurt children? Absolutely not. Was that a dumb thing to do? For sure. Does it warrant him never having his license again? I don't think so. I think the board would just as soon be able to say, go to anger management training or take a classroom management refresher. But even now, they didn't have the opportunity to do that. That individual lost his license forever. I mean, I would love for us to take a look at the whole scope of offenses and try to think about them as something that you might want to bring fresh eyes to.
Representative Bennett.
Thank you, Madam Chair. And Ms. Lugar, I'm just wondering, if I'm understanding this bill correctly, it does allow for the teacher to petition if there's been revocation and they don't believe there should be. So would that not allow for some flexibility, and maybe also just let us know a little bit of what that petition is like when a teacher does that? But I'm just wondering if that would answer or solve some of these problems that you're talking about.
Ms. Lugar.
I think that, Madam Chair, it would be, I guess I will need to learn more about the appeals process. Currently, as the law operates, you have an administrative appeal that you're entitled to as a license holder. So if the board recommended revocation, you'd have the opportunity to go through a contested case proceeding. That's true of offenses that aren't automatic revocation offenses. It's not true of the auto revoke offenses. And so if there's an appeals process, I think we definitely want to talk about how robust that is, because I guess I don't fully understand that.
Representative Bennett.
Thank you, Madam Chair. I'm wondering if our research staff could let us know maybe what's in there. Is there an appeals process?
Madam Chair, Representative Bennett, for certain offenses, these numbered offenses under paragraph B that start on page 3 and go on to page 4, that is an automatic process. For other offenses, if you look at paragraph D, which starts on line 427, those are felony and or gross misdemeanors involving a minor, and those can be appealed for good cause. That's not a process that exists or this language is new. So yes, there is currently, as Ms. Lugar was explaining, there is currently a process for a license holder who loses their license. But this language about having this broad category of felony or gross misdemeanors, that's new language. So yes, so there are certain offenses that would be automatic without that process.
Representative Bennett, follow up.
Thank you, Madam Chair. I'm still a little confused. So even when under those felony situations, the automatic revocation, there would be an opportunity for the teacher to come back and say, you know, I dropped this backpack on my child or my student's head, and it shouldn't warrant this. You know, so there is opportunity for appeal even under the felony situations, or are there situations here where there is no opportunity for appeal? That's new language.
Ms. Para.
Madam Chair, Representative Bennett, that particular offense about the student dropping the bag, I'm not sure what the conviction or what that offense was, so I'm not sure what paragraph that would fall under and what process would apply to that. It does say in paragraph F that a decision by the PELSB to refuse to renew, suspend, or revoke a license is not subject to review under section 122.188, which was a new section added last year that gave teachers whose licenses were denied a clear process with clear timelines to appeal those decisions. And that process does not apply for these denials.
Thank you. Representative Grassel.
This is for the testifier. Thank you, Madam Chair. Just watching some of the faces when you described that scenario of the teacher dropping the book bag on the kid's head, it was if a picture could say 1,000 words, there is thousands of words being spoken behind you and some of the members as well. That is something that is clearly not acceptable, and something that, if a child has that happen to them, or a student, teenager, or child has that happen to them. And that's something that needs to be addressed, because if they're willing to do something like that, what have they done that has gone unreported? Because there's impressionable and intimidatable young people here that may not report things that have happened before. And for the rest of and for the committee here, you talked about stays of adjudication. Would you explain that, please? What a stay of adjudication is, and how they come about getting a stay of adjudication?
Ms. Luker.
Madam Chair and Representative Rassel, first of all, that individual did lose his job and he did lose his license. So so those things do happen, and they would happen irrespective of the requirement that it be automatic. They would happen even if it was permissive. With respect to the stay of adjudication, the difference between a stay of adjudication and a conviction is significant. A conviction occurs following either a trial by a judge or a trial by a jury, a full hearing of the evidence, a full presentation or the opportunity to present on the part of the defense, and an opportunity to cross-examine witnesses. So full, robust law and order, what you see on TV and more. A stay of adjudication is what's called a pocket plea. An individual offers a plea to a judge who says, if you, I'm not going to accept this, and we're not going to try this case. And if you are able to remain law-abiding and follow X number of conditions, sometimes including monitored probation over 6 months or a year or 2 years, this will essentially erase the offense. It'll be as if nothing happened, and there will have been no full hearing of the issues, and individuals just given a strong incentive to be on their best behavior. Most of those are successful. I don't have data on statewide, but I can tell you that the individuals with whom I have worked have universally had a successful experience and have been able to return to teaching with no further difficulties. And I see the skepticism in your face, and I'm telling you, this is what I've lived. This is what I've experienced.
No, I'm just...
Representative Grassel, follow up.
Thank you, Madam Chair. And with the stay of adjudication, there's evidence there. And either due to a witness or a victim who was unwilling to testify, perhaps, there's enough evidence there that if they didn't accept it, they're spinning the cylinder, playing Russian roulette on whether or not, if they did take this to trial, they may be convicted of that.
Ms. Luker.
Madam Chair, true, or they may not, depending on, certainly there's a world of evidence that may exist. Some may be admissible, some may not. And the bottom line is none of that vetting or discussion or culling takes place, but what does take place is that the judge is able to monitor or manage his or her docket, and usually this occurs when you've got an individual without a history of other similar offenses. This isn't something that's given to Bernie Madoff or Tom Petters. This is something that is usually an incentive to somebody who hasn't been in trouble before to not ever get in trouble again, and that's why it's usually successful.
Representative May-Quade.
Thank you, Madam Chair. Representative Loon, I was just wondering if I could hear a little bit from you about some of the concerns here, because I just want to understand, knowing them, what some of the thoughts are for or against.
Yeah.
Representative Loon.
Thank you, Madam Chair. Thank you, Representative May-Quade, for the question. I appreciate it, because as the discussion was going on here, and my reason for bringing forth the bill is, yes, there may be situations where people made a bad decision. People did something horrible that they regret. And perhaps, I'd like to believe, I believe in redemption. I think maybe we all do. But what we're talking about here is whether or not they should be allowed to continue or to be licensed to be teachers in our classrooms. We're not saying they can't go out and do, any number of fulfilling careers in that. But we've had instances, and I can go through some of them, but, let's talk about stay of adjudication. A bus driver who received a stay of adjudication in 1998, he pled for molesting a 14-year-old girl. And so that evidence did not show up because those stays are not currently pulled with a background check. And in October of 2017, that same bus driver pled guilty to 4th-degree criminal sexual assault for molesting a teenage girl in his home. So do we want to take chances with our kids, or do we want to kind of go the extra mile of I think, erring on the side of caution? in terms of not extending the ability for someone with maybe that questionable activity in their background to be driving our children to school, teaching in our schools, working in our schools. And that is the mindset that I approach this from. Again, it's rare, as we've talked about, but even a rare instance is one that causes parents a level of concern. Are we doing everything possible to try to make sure that we are not allowing those rare instances to get through the system and possibly harm our children?
Representative Make-Weight, follow-up.
Thank you, Madam Chair. Thank you, Representative Loon. That was really helpful. I think one thing that Ms. Lugar pointed out at the beginning is it was kind of using a shovel instead of a scalpel, and I'm wondering if there's a way we could maybe whittle down our shovel to be a little bit more precise. So with the stage of adjudication in that instance, are there certain types of stages of adjudications or certain types of crimes that we could specify instead of having, you know, the few $100s with the activity fees and molestation kind of be in the same category?
Probably something for further discussion. Representative Loon.
Thank you, Madam Chair. Well, certainly, and I appreciate, I have had discussion with the testifier and about some of these things. I mean, for certain offenses, I think anything with of a sexual nature with a child, I think in my mind there should be absolutely no wiggle room there. Some of the financial crimes, theft, perhaps would be something we could talk about. But again, in those cases, we are talking about convictions as well. So even with that smaller amount of money that was mentioned with the yearbook editor, obviously the school decided to press charges. There wasn't they entered into that process as opposed to handling it internally and not going to the authorities. So, I can't speak to all of the rest of the factors around that particular case, but I'd be willing to look at ideas brought forward. But again, in many of these cases where the Board of Teaching and now PELSB has had discretion, I feel like decisions have been made that I don't believe either I would have made or the average person maybe would have made sitting on that board. I mean, if someone embezzled $160,000 of money from poor children, stole lunch money, was convicted of a felony in another state, and then gets a teaching license in Minnesota, I just don't think that's a good choice. A teacher was arrested for having 236 pounds of marijuana in their car. And their license was suspended for a couple of years, and now they're back teaching again. I'm not sure that I would have made that same decision. So again, the bill is trying to get at a little less discretion in some instances that I think most people would agree there's really not a tough call there.
Representative Bly.
Thank you, Madam Chair. These are certainly serious issues that we're talking about, and I don't question your desire to protect children from some of these crimes. However, the removal of an appeal process bothers me some in the sense that it precludes that the system is perfect or won't make mistakes. And I'm sure it's even rarer than some of the occurrences, but it doesn't mean that it isn't possible that someone within the system, because the system is made up of people, could make a mistake. And not to have an appeal process of some kind, even for things that we definitely want to stop, troubles me some. That we hear court cases where people are convicted of murder and then 25, 30 years after having been in prison discover something that shows that they weren't guilty of that crime, or even rape or something like that. And certainly we can't always catch everything, but I'm troubled by that, and I just wondered how you would respond to that concern.
Representative Loon.
Thank you, Madam Chair. Well, again, I think Representative Bly, to go back to kind of my previous discussion, I mean, we're not talking about putting people in jail, that's not the power of the licensing board. We're talking about whether or not someone should be given a license or being able to keep a license to teach. in our classrooms with our children. And again, I think we're talking about the types of offenses for which I think most people would agree it doesn't make sense to endanger children, possibly, for someone who has been, who has done certain things that are on the list provided in the bill, or there's a stay of adjudication on their record indicating there was an instance of something that occurred. So I think most people could agree, or common sense would dictate that these are instances in which it's not worth taking a chance with our children, and so perhaps this person should go find another career.
Representative Erdahl, last question.
Thank you, Madam Chair, and Representative Loon. I want to commend both you and Representative Fenton for bringing this, I think, very important piece of legislation forward. I do believe that in many cases teachers need to be held to a higher standard. I do, however, have a question or a concern, I guess, that if we are equating the embezzlement of a couple $100,000 with a stupidity or mistake involving a couple of $100, I think we need to look at that more carefully. Is there some distinction or clarification that we should make along those lines? So I would urge you to look at that.
And Madam Chair?
Representative Blue.
Thank you, Representative Erdahl. And, I think that is something that I'd be willing to take a look at. And again, the discussion was brought to me before this hearing, and it's something that I will continue to investigate.
Thank you, Ms. Lugar. Representative Fenton, would you rejoin us at the table? So members, closing comments by Representative Loon first, and we'll take care of her bill, and then we'll just allow a closing comment by Representative Fenton after I move her bill. Representative Loon.
Thank you, Madam Chair, and thank you, members. I appreciate the discussion. I think good questions raised about the bill, and again, it's uncomfortable. It's uncomfortable to raise these things because, again, I think, we all hold teachers and the people who work in our schools in such high regard, and they do such amazing work that it's unfortunate that we have to talk about these rare instances. But, again, that's what the business of legislating is often about. It's about, having the consequences for those rare things that happen, unfortunately. And I think we all want to ensure that we are doing everything possible to provide for the safety of our children, to provide confidence to our parents that we have gone the extra mile in ensuring that that the adults that we entrust our children to are ones that are going to nurture our children, keep them safe, and not provide any harm to them. So that is the intent of the bill. Again, I think by and large we do a very good job with that, but there are some instances, and I want to compliment Representative Fenton for her tremendous work in this and bringing some of these instances to light. Again, unfortunately, some very disturbing news stories that led us both to take action to say our laws are not as strong or as tight as they should be in this area, and further action is needed. So, I take to heart the questions raised on maybe some of the financial crimes and the level of which that should rise to the level of removing a teacher from licensure, and I'm going to take those comments back and as well as the fees and the randomly doing a recheck on the background of licensed teachers. We'll take a look at that. I certainly don't want to unduly burden school districts with that. I certainly would not expect teachers to pay for those, and so we'll continue to work and refine this bill as it moves through the process.
Thank you, Representative Loon. With that, the chair renews the motion to re-refer House File 2795 as amended to the Committee on Transportation. All those in favor say aye. Aye. Those opposed, no. transportation policy. I stand corrected. So the chair renews her motion to re-refer 2795 as amended to the Committee on Transportation Policy. All those in favor say aye. Aye. Those opposed, no. The motion prevails, and the bill is on its way. Thank you, Representative Loon. Representative Kunish-Padin, would you move the minutes, please, from March 1?
I so move and approve the minutes from March 1st, 2018.
Representative Kunish-Padin moves approval of the March 1, 2018 minutes. Is there any discussion? Hearing none, all those in favor say aye. Aye. Those opposed, no. The motion prevails and the minutes are approved. Then the chair moves House File 2777 to lay over. Representative Fenton, closing comments.
Thank you, Madam Chair, members of the committee. You know, I have been probably in almost every facet in the classroom. I've been a teacher, I was a school administrator, I was a volunteer in the schools, I was a substitute teacher, I'm always a parent to 3 children, and I was a Sunday school teacher as well. And my intent in this bill is to make sure that the safety of our children in our classroom comes first. One thing that you don't know about me is that I'm also a victim of assault at the age of 14 years old. And while this didn't happen in the school, it did leave an imprint on my life to this day that I think about. And if I could prevent anything from happening to any of our children in every classroom across the state, I'm going to do it. And so with that, there were some unfortunate circumstances, people getting licenses that shouldn't, but we do have one of the best teaching staff in our schools across the state. This pertains to a few, but a few too many. So with that, Madam Chair, members of the committee, I have nothing left to say.
Thank you, Representative Fenton. The chair lays over House File 2777. Thank you, and thank you to everyone who came to testify to inform us of this very important issue. Representative Davnie, I thank you for having waited patiently. Representative Ward moves House File 2794. Welcome to our committee, Representative Davnie. We miss you.
Yeah, I miss all of you as well.
Well, I certainly miss you. Well, I won't go into that.
Yeah.
I remember.
Why don't we stop there?
A few meetings when we really counted on you to help us complete a discussion, and he's left, so I can say it was Representative Erdl. Remember our prolonged discussion on civics many years ago? Yes. Well, welcome to our committee. Please say your name for the record and introduce 2794.
Thank you, Madam Chair. Representative Jim Davnie. House File 2794 is a outgrowth of a Channel 5 TV news story of last fall, where they determined that from the 1980s through to the late 20-aughts, at that time Board of Teaching had in their disciplinary process, had failed to notify authorities of allegations of inappropriate behavior by teachers that should have been reported under current law. And the Board of Teaching at that time said, we're not mandated reporters. And in fact, they weren't, except individuals who were on the board who were mandated reporters in their other roles. What House File 2794 does is include members and staff of both the Professional Educators Licensing and Standards Board and the Board of School Administrators as mandated reporters, so that in the infrequent case, which I think is the understanding here, that a complaint comes directly to the board rather than up through a process where the allegation would have been reported to authorities earlier. It is, in fact, reported to authorities.
Thank you, Representative Davnie. Questions for Representative Davnie? Seeing none, Representative Davnie, you did a really good job, and thanks for being to the point and reminding us that Pelsby and BOSA are mandatory reporters, and we want that to be in law, reinforced. So members, with that, the chair lays over House File 2794. Thank you, Representative Davnie.
Thank you, Madam Chair and members.
Representative Christensen. Representative Christensen, welcome to the testifying table. Your bill will be going to public safety. If you'd like to move House File 3203.
Thank you, Madam Chair. Madam Chair, I move House File 3203 for referral to the Committee on Public Safety.
Will you please describe your bill?
Thank you, Madam Chair. Madam Chair and members, you know, this bill came forth somewhat as a surprise. I think there was some reporting done by KARE 11 about some instances around the state, but specifically an instance in my district in Burnsville of inappropriate sexual relationships between teachers and students who were who were 18 or older. And I think in my conversations with constituents and you know, people involved in education, a lot of people didn't realize that this wasn't actually illegal in Minnesota. And I think this was really brought to our attention by some of the reporting in the media, as well as Dakota County Attorney Jim Backstrom. And I think, and this is a really important issue, I think Minnesotans can all agree that these sorts of relationships are entirely inappropriate and deeply concerning and disturbing. In this bill, essentially just to go through a little bit of the meat of the bill, adds teachers and those in a position of authority over students in a school. It makes that a sexual assault in the third degree, or a sexual misconduct in the third degree. And so it basically extends the protections afforded to students under the age of 18 to students over the age of 18 up to the age of 21, which is the high end of students that we have in our schools. And I'd be happy to take testimony and questions, Madam Chair.
Thank you, Representative Christensen. Are there questions for the author before we go to testimony? Representative Kunesh-Podein.
So the legal age, consent age is what?
Representative Christensen.
Madam Chair, I would refer to council, but I believe it's 16.
Mr. Diebel.
Madam Chair, Representative, the legal age of consent is 16, but it is 18 in positions of when the perpetrator is in a position of authority.
Thank you.
Thank you, Mr. Diebel.
So this would then extend that age of consent, that 18 years of old, to 21. Is that correct?
Representative Christensen.
Madam Chair, Representative Kunesh-Podein, yes, because students are allowed to stay in school until they're 21 in Minnesota. So it affords those protections then that was previously ended once you turned 18 to 18, 19, 20, and 21-year-olds who are students.
Representative Kunesh-Podein.
And then my other question is this, I'm just trying to understand in what circumstances this 18 to 21 issue is. Are we talking about just high school students? Are we talking about college kids? Are we talking about technical schools? What are we talking about here?
Representative Christensen.
Madam Chair, Representative Kunesh-Podein, we're talking about high school students.
Okay, thank you.
Are there any other questions for the author? Let's hear your testifiers, Representative Christensen. I believe we have Mr. Backstrom from Dakota County Attorney's Office. Oh, excuse me. Well, you come forward anyway, because we're going to hear from Representative Gruenhagen shortly. Representative Christensen, did you have any specific testifiers?
Madam Chair, no, not other than I think Mr. Backstrom wanted to offer a couple of comments and to be here as a resource from a county attorney's perspective.
Yes, thank you. Mr. Backstrom, welcome to our committee, and please say your name for the record and make any comments that you think are relevant to this. We're also going to have Representative Gruenhagen's bill shortly.
Thank you, Madam Chair. James Backstrom, Dakota County Attorney. I have had the privilege of serving as the county attorney in my community for a little over 30 years. I appreciate this bill. And just for your information, Representative Gruenhagen's bill 3035 is virtually identical to this bill. So, you may want to consider these together. I've been working with Representative Gruenhagen, but I appreciate Representative Christensen bringing this forward as well. This is an important issue. This is an issue that needs to be addressed, and I have raised this issue before, and unfortunately, it didn't get changed, but we've had 2 cases in Dakota County, and there's been cases in other jurisdictions as well, where we were simply unable to prosecute a teacher. In one case, it was a coach having sex with an 18-year-old high school softball player under his supervision. In another case, it was in Burnsville. I forget what type of teacher it was, but again, it was an 18-year-old high school student where there's a sexual relationship going on. It simply shouldn't occur. In my view, it's unconscionable for a teacher in high school to be having a sexual relationship, or anyone who's working in high school, whether it's an administrator or an independent contractor or a volunteer, if they're in a position of authority over a high school student, whether that student is 18, 19, or up to age 21, which they could be, it should be a crime. And that's what this bill does. It's an important bill. It's supported by the Minnesota County Attorneys Association, on which I serve on the board of directors of, and I would thank you for your consideration. I'd be happy to answer any questions you might have.
Thank you, Mr. Backstrom. Questions, Representative Makewaid.
Thank you, Madam Chair. I just have a question. This might be for Christina, but this also could be for Mr. Backstrom. What is the difference in definition of secondary school between these 2 bills that we're looking at?
Ms. Para.
Madam Chair, members, the definition that is in House File 3203 is a broad definition. It's consistent with how schools are defined under Section 120A22. So it's anywhere that students fulfill their compulsory instruction requirements, and that might include homeschools, for example. It could include really a variety of arrangements, including service co-ops or anything that school districts, charter schools, and non-public schools do. The definition in House File 3035, it gives more examples of these types of schools where students may fulfill those requirements, but it doesn't reference the compulsory instruction requirements. That's really the difference. Is House File 3203 brings schools more under that umbrella rather than specifically naming them.
Representative Makewaid, follow up.
Yes, Madam Chair, thank you. Maybe not. I'll have to look at this. Thank you.
Sure. And when Representative Gruenhagen comes forward, you could ask that question as well. Other questions for the testifier? With that, I think we have another testifier, Mr. Prokopowicz, who's a chief deputy, who's here for Representative Gruenhagen. Do you wish to say anything on this particular bill? No, we can wait for Representative Gruenhagen's bill. No. So with that, the chair renews Representative Christensen's motion that House File 3203 be re-referred to the Committee on Public Safety. All those in favor, say aye. Aye. Those opposed, nay. The motion prevails, and the bill is referred to Public Safety.
Thank you.
Representative Gruenhagen, last bill on the agenda for today. Members, thank you for being here quite timely today in spite of the weather. We started officially, I think, not too late. That was very good, so I appreciate that you considered this, because I just did not know how long these bills might take today. Representative Gruenhagen, the chair moves 3035. And you have an amendment. The
Yes.
chair moves H3035A1 amendment. Would you introduce yourself, Representative Gruenhagen, and then explain your amendment?
Representative Glenn Gruenhagen, and the amendment is simply clarifying language for the bill.
So is there any discussion on that clarification that was inserted after the word school in both of those page references, page 2 and page 4? Hearing none, all those in favor say aye. Aye. Those opposed, nay. The motion prevails and the amendment is adopted. Okay, Representative Gruenhagen, explain your bill in its whole.
Okay, thank you, Madam Chair, and thank you, committee members, for hearing this bill. A couple things about the bill. The Minnesota County Attorneys Association did vote to support the bill. Also, a Representative Mikasa this morning told me that they're full support of the bill. Looking over the bill, you'll see that it greatly increases to the 3rd and 4th degree sexual misconduct by not only teachers but independent contractors, volunteers, and any other school employees. You know, one of our former presidents said that speak softly but carry a big stick. This increases the stick of sexual misconduct as far as our schools and protection of our children are concerned. With that, I'd like to introduce Dakota County Attorney Jim Backstrom to comment on the bill.
Welcome again, Mr. Backstrom, and please comment on House File 3203 as amended.
That's 3035, Madam Chair.
Excuse me, 3035 as amended. Thank you.
Thank you, Madam Chair. James Backstrom, Dakota County Attorney. Again, I appreciate the opportunity to be here. And I didn't mention this earlier, but I just want to say this because this is the Education Committee. I have great respect for teachers and the teaching profession. My sister was a teacher for over 35 years before she retired. And I just wanted to note that for the record because I really have great respect. But one thing that I will say is that teachers are in a special position of authority over the students that they work with, as are any school administrators, any contractors, school bus drivers, and the like, that come into contact with students while they're in high school. They should not be allowed to be in a situation, regardless of the student's age, to have a sexual relationship with a student who has not yet graduated from high school. And as I mentioned, this bill is virtually identical to Representative Christensen's Bill 3203. These are important changes. Current law, under Minnesota law, it is a crime for a teacher, a school administrator, and the like, who is in a position of authority over a 16 or 17-year-old student, if they're at least 48 months older than that person, and then they have a sexual relationship with that student. That is a crime, but it is not a crime under current law if the student is 18 years of age or older and still in high school. This is simply not appropriate. You know, these types of relationships, even though you might say this is a consensual relationship, it's, in my view, something that the student is put into a very difficult situation. These are vulnerable children. They are not yet adults, and they haven't graduated from high school. The long-term negative impacts of these relationships can be very traumatic on students. I once had a young woman come into my office, this was years ago, and talk. This is when she was in her mid-20s and just finishing up her college degree, and she talked about how she had been traumatized by having a sexual relationship with a high school teacher. And I told her, unfortunately, there is nothing I can do under the law because it's not a crime under the current law. And that's why we're here. We're here to make this important change to the law, to address these situations, to avoid these types of long-term negative impacts on youth, and to make sure that our teachers and our school administrators and independent contractors or volunteers that are in a position of authority over these students do the right thing and do not have sexual contact or relations with these students. So again, I appreciate the opportunity to be here today to testify. I want to thank Representative Gruenhagen as well for his leadership on this, and would appreciate your support. Thank you.
Thank you, Mr. Backstrom. And Mr. Prokopowicz?
He's not going to be here.
He's not going to be here. Thank you very much. Then let's hear from Education Minnesota. Ms. Lugar, did you want to comment? Not on either of these bills. Thank you. I think the Department of Education wanted to comment on the entire scope of today's bills. So, Mr. Uni, please come forward and share any message you have. Welcome to our committee. Say your name for the record and begin.
Madam Chair, representatives, my name is Adoshuni, Director of Government Relations with the Department of Education. Thanks for the opportunity to just make some general comments about the discussion today. I'd say the department welcomes having this discussion about creating the best atmosphere for our children and looking at standards for teacher conduct. We're keenly aware and recognize the concerns that I think a lot of stakeholders brought up in multiple areas, and we welcome having those conversations with the authors and with the stakeholders about coming to a mutual agreement, mutually agreeable conclusion for these bills where we can create the best situation for our students. Thank you.
Thank you, Mr. Uni. Any questions for the department? Representative Ward. Representative Ward has a question for Ms. Para. Please proceed.
Thank you, Madam Chair. Ms. Para, could you explain what difference there is between these two bills and why we have two bills essentially addressing the same thing? There must be some fine lines.
Ms. Para.
Madam Chair, Representative Ward, the only part else I can speak to is the difference between the definitions of secondary school in these two bills. And as I said before, the definition in 3203 refers more to our requirements for compulsory instruction where those can be fulfilled. The definition in House File 3035 doesn't reference the compulsory instruction and just refers more to the specific statutes. For the differences with regards to how they amend Chapter 609, I would refer to my colleague, Mr. Diebel.
Mr. Diebel.
Madam Chair, Representative, the key difference after the amendment is that the Gruenhagen bill refers to volunteers as well as independent contractors and employees. So it's a broader net who would be covered by this.
Okay.
Representative Ward.
Madam Chair, thank you. I'm just curious as to any benefit that we all might receive as these go through various committees and a very tight timeline, if the authors might consider consolidating or working together in some way so we don't have two parallel bills that essentially do the same thing.
Representative Gruenhagen.
Well, thank you, Madam Chair. Yeah, my suggestion would be that Representative Christensen and I get together with Attorney Backstrom and come to a similar bill, and rather than have the similar bills with some differences parallel go through the committee process.
Thank you, Representative Gruenhagen. Are there other questions for either Mr. Uni, Representative Pryor, for Mr. Uni?
No, not for Mr. Uni.
Are there any other questions for the department? Thank you, Mr. Uni, as usual. Is there anyone in the audience who wanted to testify for or with concerns about this proposal or the previous proposal? Because the chair will be laying over the Gruenhagen proposal so that he could work with Representative Christensen. Questions for Representative Gruenhagen. Representative Pryor.
Thank you, Madam Chair. My question is, so your legislation does include volunteers as part of the definition, and I'm wondering when you're talking about having authority over a student, is that possible to find how a volunteer has authority over a student as a, I think when you're a teacher, you're a coach, a contractor, but a volunteer in a classroom, is that, do we have other, is that, it seems to me that would be more difficult to explain or to qualify.
Mr. Diebel will take that question.
Madam Chair, Representative, position of authority is a term of art used in Chapter 609 for the criminal sexual conduct offenses. There are two parts to it. One speaks to any person who is a parent or acting in the place of a parent and charged with any of a parent's rights, duties, or responsibilities to a child. And the second part, and this is where likely the volunteer might be ensnared by this provisions is that a person who is charged with any duty or responsibility for the health, welfare, or supervision of a child, either independently or through another, no matter how brief, at the time of the act.
Representative Pryor.
Yep, Madam Chair.
Representative Gruenhagen.
Yeah, I knew that too. I just wanted to see if Mr. Debo knew that.
It was a test. Yes, Representative Gruenhagen, we know you like to give tests. Thank you very much. Thank you, Mr. Debo. That was excellent clarification. Representative May Quaid.
Thank you, Madam Chair. And this might be for one of the two researchers. Are homeschools covered under 3035? I see it mentioned in 3203, but not in 3035.
Ms. Farah.
Madam Chair, Representative McQuaid, yes, in House File 3203, it is included because that is where compulsory instruction can be fulfilled. I don't believe it is covered under House File 3035.
And Mr. Debo, I don't think I need to turn to you for that because Ms. Farah is the expert in education code. Representative May Quaid.
Thank you, Madam Chair. Representative Gruenhagen, I would suggest you expand the scope then of your bill to include all the types of compulsory, wherever it can be fulfilled or whatever the legalese may be, that is represented in 3203.
Representative Gruenhagen.
Thank you for
I
that.
think that's what you plan to do is work with Representative Christensen. Are there any other concerns, questions about these proposals? This proposal in particular, the chair renews her motion that
Madam Chair.
Excuse me?
Could I just make a
Oh, yes,
quick closing
Representative
comment?
Gruenhagen, if you'd like to do closing comments, of
I
course.
normally am short on words, but this time I'm not. So no, I just want to say too, during my tenure as a school board member, which if we want to know how many years, you can check with Representative Erdahl. He keeps track of that. But I dealt with some sexual misconduct, and one of the discouraging things is we were told in closed meetings to and this happened to be a teacher, that to give him a clean record, and I think we paid him a certain amount of money to leave the district, even though there were numerous allegations of sexual misconduct against him. The interesting thing is about 2 months ago, I was interviewed by a local police officer. He wanted to interview me about that situation that occurred while I was on the school board. And what happened, this particular former teacher was now employed at a nursing home, and he was accused of sexually misconduct toward women nursing home patients, okay, if you can imagine that one. So I definitely think we need stronger consequences here because the recidivism rate or the repeat offender of this type of behavior seems to be at a very high level. So thank you for your support.
Thank you, Representative Gruenhagen. The chair lays over 3035 as amended. Is there any other business to come before this committee? We will see you again on Thursday. We will have a very full schedule, so look forward to seeing you. This meeting is adjourned.